friends. Today, let us understand a very important case law. Dow Chemicals International's Private Limited versus the Commissioner of the State Tax. A very important judgment which will help you to understand. This judgment has come by the Appellate Tribunal, Delhi. The subject matter is foreign entity procurement service for the group companies taxable as imports, not intermediary services. Let us understand in detail. The appeals were dismissed, and the first appellate authority order confirming the rejection of refund claim were upheld. The tribunal ruled that the procurement services received by the Indian entity from its foreign group companies are taxable as import of service under the reverse charge mechanism rather than qualifying as an intermediate service, which would place the supply outside India. The key reason was the foreign entity provides core procurement services on its own account as an independent contractor, not merely auxiliary facilitation services between the two principals. Let us understand the facts in the dispute. The impugned action. The Joint Commissioner of the State Tax Appeals confirmed the rejection of refund claim for the IGST paid under the reverse charge mechanism on the procurement services received from the Dow Europe GmbH for the period January 22 to June 22, totaling approximately rupees 13 lakh crores. The petitioner's argument. Let us understand the petitioner's argument. The appellant argued that the services provided by Do Europe were in nature of intermediary services under Section 2, subsection 13 of the IGST Act, making the place of supply the location of suppliers Switzerland under the Section 13, subsection 8 of the IGST Act, and thus not liable to GST. They contended that after initially paying the IGST under the mistaken impression, they reversed the input tax rate and sought a refund. The core question flaw was whether the procurement service provided by the Dow Europe, a Switzerland-based centralized procurement hub for the Dow Group, to Dow Chemicals International Private Limited India qualifies as the intermediary services under Section 2, subsection 13 of the IGST Act, thereby determining if the place of supply is in India, the import of the services or outside India not liable to GST. The key findings. The tribunal considered the definition of intermediary services under the Section 2, subsection 13 of the IGST Act and clarification provided by the Circular Number 159 15 2021 GST dated 28 September 2021, along with various High Court judgments to determine the nature of service. Minimum three parties. While the arrangement involved three parties, appellant Do Europe and foreign suppliers, satisfying one prerequisite, the tribunal noted that Do Europe and Do India are subsidiaries of Do Inc., the Do Group, with the Do Europe functioning as the centralized procurement hub, providing a core service to the entire group. Two distinct supplies. The tribunal found that the second requirement of the two distinct supplies, a main supply between the two principals and auxiliary facilitating supply, was not satisfied in this case. The services on own account. Do Europe provide services on its own account to services receiver in India, acting as an independent contractor and does not merely represent or bind the Indian client, thus falling outside the exclusory class of the intermediaries definition. The High Court precedents. The tribunal relied on the High Court judgment in Columbia Sportswear India Sourcing Private Limited versus the Union of India. This case, through involving an Indian entity exporting services, established that such supplies, buying supports, or marketing services were not intermediary services but service provided on the principal to principal basis, as a principle extended by the analogy to the present case. The advanced ruling authority versus the High Court. The tribunal reiterated that a ruling by the advanced ruling authority, such as Airbus Group India Private Limited and the Global Reach Education Service Private Limited, were merely persuasive and not binding, unlike the High Court judgment, which have a binding authority. Nature of procurement and contractual terms. The tribunal scrutinized the nature of procurement services and the terms of agreement to ascertain if they constitute intermediary services, core services versus auxiliary services. Do Europe role as a centralized procurement hub within the global Do group involves providing core services to the entire group, which goes beyond merely facilitating or arranging a supply between the two independent principals. The independent contractors relationship, the procurement arrangement explicitly designate Do Europe as an independent contractor without authority to bind the Do India. This contractual provision supports the tribunal's finding that the services were rendered on the principal to principal basis, rather further differentiating them from the intermediary services. The ruling. Let us understand the rulings. Outcome. The appeal was are dismissed and order passed by the first appellant authority, which confirmed the rejection of refund application are upheld. Directions not applicable. Liberty. The tribunal clarified that while the appeals were dismissed, the first appellant authority viewed that the refund application was an afterthought was incorrect, as the Section 54 of the CGST Act provides for the refund of the taxes paid under the misconception within a specific time limit. However, no specific liberty to the revenue for the future action or to the appellant was granted in the final verdict. A very important judgment which speaks about intermediary and the principal to principal basis. Hence, a very important judgment. You can read this judgment in detail and understand further. If you have any queries, put the comment and I will revert back with what exactly you can do to understand and implement this judgment in your case if it's relevant. Thank you and subscribe to the channel if you like it.